Case number 118204 in the matter of Matthew Edgar Holt.
May it please the court, the Office of the Disciplinary Administrator appears by Kimberly Knoll, Deputy Disciplinary Administrator. Mr. Chief Justice, if I could reserve 2 minutes for rebuttal, please.
2 minutes is granted.
Thank you. This is an original proceeding in attorney discipline. There were a total of 4 cases presented to a hearing panel. The first one involved multi-jurisdictional practice in Iowa in which the respondent didn't file the paperwork and pay the fee to be able to practice within the state of Iowa under his Kansas license. At the time, he indicated he was leaving Iowa, so they told him it was okay, that he didn't have to do it. They determined he didn't timely leave and shut down his operations, and he ended up being admonished. He did not report that admonishment to our office. The second case involved a request to obtain citizenship for 2 children who were residing in Kenya. In that case, he repeatedly told the clients that the case was moving forward. They were checking with immigration and they were unable to determine whether anything had been filed because it had not. Ultimately, they filed a complaint. He refunded the money and the representation ended. The third case involved an Australian national who was working in Overland Park. She was here on a work visa that was getting ready to expire. She was going to have to return to Australia for some training and some media and some review. She contacted Mr. Holt and explained that she needed the visa to be able to continue to work. He assured her that he had done many of them, and what he ultimately did was change her status to one that she was a visitor. She was unable to work. She ended up having to go back to Australia in order to get everything corrected. She did ultimately file a civil suit against him. She obtained a default judgment, and then that resulted into a garnishment. And during the temporary suspension hearing before this court, Mr. Holt acknowledged that he has opened up a subsequent account that was not subject to the garnishment. The fourth case involved an individual that was a British-born individual who was seeking dual citizenship. She had 2 concerns, and a British passport. She had 2 concerns. One, she didn't want to cause problems with her American citizenship if she became a British citizen, so she was looking at the dual citizenship, and she wanted the passport. She ultimately did her own research and found out that she didn't have a problem becoming a dual citizen, and her passport application was ultimately declined because he didn't understand the difference between European dating and American dating. At the hearing, he agreed to refund the retainer, part of his retainer that was unearned, and the application fees. The information I have as of August 30th, he made 2 payments totaling $500, so that has not been completed. During the hearing, he stipulated, both before and during the hearing, to all of the alleged rule violations. The issue became disposition. He submitted an untimely probation plan that was ultimately rejected by the hearing panel. There's been no affidavit filed before this court of any kind of compliance as to his proposed probation plan, and I have had no means to be able to confirm whether he has continued with treatment or his association with CALAP. At the hearing, I recommended an indefinite suspension. The panel also recommended indefinite suspension, and here today, I renew that request.
Has there been any, or do you know of any effort, or has there been anything paid towards the judgment that was entered? Do you know?
I do not know.
Okay.
And just so I'm clear, the judgment that Justice Rosen's, I wrote on my notes here, the $750 filing fee and the $100 attorney's fees paid to CW, and the panel that the respondent had agreed to pay those to CW, but the panel was not aware whether that action had been taken. Do we know whether that action has been
Yes,
taken?
that was what I was referring to. CW has been paid 2 payments that total $500, but not the complete amount that he agreed to pay at the panel.
I'm sorry, I must have missed that. Okay.
Counsel, you made reference to the 2 different accounts, and you said that the respondent made reference to them when he was here on an earlier matter. And there was a garnishment request outstanding on one account, and then he transferred funds from that account to a new account that he established. Am I correct so far?
I carefully reviewed arguments from the temporary hearing, and I do not recall him saying that he had transferred funds. Justice Beyer asked him if there was enough money in the account to pay the garnishment, and at that time it was not known that there was a secondary account, and he said no.
No, there was not enough money in what I call account number 1 to pay the garnishment.
That is my belief of what the test or what the discussion was at the first hearing. And then I believe it might have been it was either Justice Johnson or Justice Siegel that asked about where the client money actually was going. And he said that he didn't have a trust account, that he had opened up a second, I think he used the word checking account or operating account. And the inference was that that was not subject to the garnishment. And then I got up and said, this is the first that I've heard of this second account, and I have concerns that the garnishors are not aware of this account to be able to figure out the garnishment.
And given that, my follow-up question is, are you contending that this was an attempt to defraud the creditor, the judgment creditor?
Mr. Chief Justice, I do not believe Mr. Holt has ill intent. I haven't believed it from the beginning. I believe that he has significant competency problems. I could see a scenario in which he thought, well, my office account is being garnished. There's been all of this discussion about protecting client money. When he was here before, you asked him whether or not he had set up a trust account. He said no, but he would go out and get one. I could see a scenario that he believed that setting up a secondary account was necessary in order to protect client money from the garnishment. Because I do believe that client money is going into whatever he calls this account, because he doesn't have a trust account. And the pattern was that he was accepting funds up front prior to the work being completed. So I can see a situation in which he thought he was doing the correct thing and didn't really give it a second thought that he needed to report that second account to the garnishers.
All right, thank you.
But I will acknowledge, I did suggest that I had concerns that that could have been the scenario because I was so surprised that there was a second account.
The scenario being it
Being
could
there-
have been a
Absolutely.
fraudulent intent.
Absolutely.
All right. Thank you. Any more questions?
I do. I have one question. At page 33 of the final hearing report, when the panel is discussing mitigating circumstances, they state that the respondent provided a response to the initial complaint filed by JWEV and CW. This is under his present and past attitude of the attorney as shown by cooperation during the hearing and full and free acknowledgement of the transgressions. Do you agree with the panel that his response to the JW complaint acknowledges responsibility for the transgressions?
May I go back to council table and get that response?
Sure, and that's at page 14 of the final hearing report, the quote from the response. That's what I'm looking at.
Okay.
I directed you to the mitigation finding first, but the actual extended quote from the response is on page 14.
Now I do recall. I think in Mr. Holt's way, this is how he acknowledges. I think it goes back to more of a competence issue. I don't think he realizes the depth and the breadth of how his actions were not correct and implicated the rules. And I think in his mind, I will give them back their money, even though I did do work, was his way of acknowledging. Did I answer your question?
Yep. Okay. Thank you.
Any further questions? Thank you, counsel.
May it please the court, Matthew Hall, appearing pro se today. And at this time, I'd like to waive my right to oral argument.
Do we have any questions for counsel?
Does that mean you agree with the recommendation of the panel and the disciplinary administrator on the suspension?
Yes, Your Honor.
Okay. Thank you.
Anything else? All right, thank you, counsel.
Thank you.
You're reserved 2 minutes for rebuttal.
Mr. Chief Justice, I would waive unless there's any additional questions.
I see none. Thank you. I thank you both for your comments this morning. Court will take this matter under advisement. That